as we saw, the three steps that you told us. Just one second, I'll just go back to it.
Correct.
Notice of removal to the speaker.
Yes.
Resolutions given to the governor and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful. I'm grateful.
Right. Now,
fourth step.
Suppose notice of removal of the speaker. We are not really called upon to adjudicate upon the validity of the.
Except in Navam Rebia. Your Lordship, if your Lordship chooses to refer, would have that issue. Navam Rebia,
if we choose.
In the broad, no, I'm saying it arises. I'm not saying your Lordship may have to for this case. I'm saying that's the core issue. I'm saying it's an issue.
The governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying...
Picking out a person, because
correct.
Even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. That there was no valid material at all on the basis of those three circumstances.
That's a core question. And that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyan aur bhi बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं." उसने वो भी सुना जो मैंने कहा नहीं. The governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 as the resolution is held there. So he's hearing things.
The resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very...
I'll be dealing with Bomai. That's the core question. Your Lordships is saved a lot of unnecessary exercise if your Lordship comes to that conclusion plus follows Bomai. Which in any case is...
So then according to you, what? We reinstate the Uddhav Thackerey...
Straight away, let me change my tack and go to Bombay.
But you resign, no?
No, I covered in my note directly. 5 reasons. Justice Shah asked me that in the beginning, your Lordship asked me that. I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Mr.
No, I'll deal with it. So let me deal with
it.
Let me deal with that.
It's like the court being told that you reinstate a government which has...
No, it's
an acknowledgement by you.
I hear your Lordship loud and clear. It's a question asked earlier, and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapil, how can, just hypothetically,
yes.
How can the court reinstate a chief minister who did not even face the floor of test?
Your Lordship is not reinstating anybody.
And what will be the consequences?
Your Lordship is and should and does, and Bommai says it more graphically, restore status quo ante. That's the meaning of a...
But Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that.
Because then... Clearly, you have been ousted from power because of a trust vote which is set aside.
Correct. Duty bound to satisfy Lordship, and I believe that.
Right. Now, our problem is look at the intellectual conundrum.
Yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to. For whatever reason, you didn't want to face the trust vote.
I face that squarely. Allow me, I'll change my sequence and come to that first right now. May I, Malus? Because straight away your Lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law your Lordships. If your Lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, Malus? That is, this affirmative and negative code.
Yes, that you
with only one. So let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if your lordships were to accept their interpretation? That's a good way of answering my proposition. Namely, your lordship will have nothing left in the 10th schedule. How does the lordship operate? Both the 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule. That's my first point. Second point on resignation. Now, the most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act, the consequence of that is known to me. The CM's participation or absence of participation would not dilute that fundamental illegality. If it is illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordships powers are unique in this country, in that even your lordships can go beyond the law. Not contrary to law, beyond the law. Then what's the point if the governor's actions are held to be illegal? Actually, your lordships would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
189 is said in the context of the vote in the House.
So,
with respect to...
Exactly. So, therefore, 189, your lordships can and may, and in this case perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra government made a liquor policy, therefore that is gone.
What you're saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid.
Correct.
But that does not validate the original appointment itself.
Or calling for that goes back to the same thing, First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot...
What you're saying is that if the calling of the voting in the House itself is subject to...
Just how my lords formulated, right or wrong, governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
But that's affirmation of the House, right? Then what? I still have it.
Affirmation is coming. That's this section. Bomai dealt with the affirmation.
All right.
Bomai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, it will be quashed. So this is, the 3 points are covered. Prohibitory, affirmative, 189, and resignation. Now, the fourth point is this prospective and retrospective of the EC. They're all important queries which fell from my lord. My lord, the Chief Justice asked this question more than once. Petition is filed on 19th July. 17th February is the order. Now, well, the order to be retroactive, question number 1, retroactive from when? There are 3 possibility retrospectivities. Look at the consequence. Well, the Lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was 1990 or 92. I'm giving you 3 alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only 3 possibilities, Malas. In all of these, the consequences would be that, Malas, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification, if your Lordship relates back that. So your Lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your Lordships will not avoid the inevitable consequence by, of course, your Lordship's words can always, that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, I am liable to something, or from actually, logically speaking, from the origin. Therefore, this... Election. Huh? And, it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. January, yes. Would also go without there being a fresh election unseating him. Everything will go, No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next one, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a Lordship of Rajendra Rana. Now note this, note this. Not a single judgment even of any High Court, leave aside Supreme Court, says that the Election Commission will relate back. A Constitution bench has held the field for very long saying a disqualification 10th schedule order relates back. If your Lordship were today to do this, your Lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a Constitution bench to relate back. And your Lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, suppose tomorrow the Speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to June 22. But there cannot be disqualification because by then your Lordship also would be applying a EC order retroactively. Therefore, your Lordship already has jurisprudence and a precedent.
Prospective according to you. All right.
Then, the fifth aspect is this political party and legislative party.
F.
Now, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibal's. The 10th schedule defines a legislature party in terms of a political party. That is, conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And your Lordship is concerned with a whip. Whip is peculiarly a political party activity.